Thank you so much, Peter. Thank you for the introduction and good morning, everybody. Welcome to this European Summit on the ICJ's request, or the request of the UN General Assembly to the ICJ, the International Court of Justice, for an advisory opinion. That'll be the main topic of our talks and considerations this morning. And I want to take you just on a little bit of a journey. This case has not been very much in the media. We've heard a lot about the genocide cases in the International Court of Justice. We're more familiar with what's going on at the International Criminal Court. But nobody's really speaking about this case, which we're waiting at the moment for the court to come with an advisory opinion about the legal status of the so-called occupied Palestinian territories. And that's what I want to share with you this morning. So we have two main international courts here in The Hague, the International Criminal Court and the International Court of Justice. The International Criminal Court is a court that prosecutes, investigates and tries individuals for crimes under the Rome Statute, war crimes or crimes against humanity under the statute. The International Court of Justice has two functions. It hears contentious cases between states. They are matters that are brought by consent by states to the court to be resolved. It can advise the instruments and organs of the United Nations on specific legal issues when they ask the court to do so. Contentious cases have to be brought by the consent of the states involved. The Court of Justice has no jurisdiction to take initiative against member states. It's very much based on the idea of the sovereign equality of states. States consent to have their rights and obligations adjudicated by the courts. So what often happens is under a treaty, for example, a treaty will have a provision saying that disputes arising under the treaty are to be referred to the courts. And in that way, when that happens, that's the case with the genocide conventions, the court comes into play because the parties have agreed that will be the case. The advisory opinion, Peter mentioned the Wall advisory opinion almost exactly 20 years ago to the day. That was very influential in the court deciding that the barrier that Israel built was an infringement of Palestinian rights to self-determination, and that Israeli building of settlements is illegal. That is a non-binding opinion, by the way, of the courts. So we have the International Criminal Court. The situation in the state of Palestine is related to the case in the International Court of Justice, because the big question, or one of the main questions in the criminal court's proceedings, is whether or not the state of Palestine exists, and if it does, what is the territory of that state? The court only has jurisdiction, because Israel is not a party to the International Criminal Court, only has jurisdiction over Israelis if those crimes are committed on the territory of a state that is a party to the treaty. And the court has considered the question, is Palestine actually a state that is a party to the treaty? And it made a decision 3 years ago now, that a preliminary decision that the court feels that Palestine is enough of a state for the moment to be considered worthy of being a state party that the court can have jurisdiction over. But that matter is up for grabs at the moment. The court has invited parties and others to make submissions to the court about its jurisdiction. And a number of people around in this room are involved in preparing submissions to the court on that matter. So the core of the matter is similar to the International Court of Justice, is the question of Palestine's status. Is it a state? How can it become a state? And how is its territory to be determined? The advisory opinion was a request by the General Assembly in December 2022. 87 UN member states voted for a resolution to ask the courts to issue an advisory opinion. This is the question of the questions that have been put to the courts And in yellow highlighted are the key provisions. The first question is the critical one: what are the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement and annexation of the Palestinian territory occupied since 1967, including measures aimed towards the holy city of Jerusalem, and thirdly, from Israel's adoption of related discriminatory legislation and measures. And then next, what are the consequences that arise for all states as a result of that? Now, who were the sponsors of this resolution? They were Algeria and the other states you can see here. These are states that are not particularly friendly to the existence of the state of Israel, and it was co-sponsored by further states who similarly have a political objective of undermining the sovereignty of the state of Israel. You can see here how the voting happened in the General Assembly. So 87 member states is not a majority in the General Assembly. It's not a half of the members. But because resolutions are adopted by a majority of states present and voting, those 87 member states were able to pass this resolution. So we're talking about a minority of states in the UN who are behind this initiative. This, I think, is one of the most remarkable things about this case. It's not like the world overwhelmingly is supporting this idea. No, on the contrary, over half of the UN member states are not supporting this initiative. Some have opposed it, only 26. 53 have abstained. That's very common in the UN General Assembly, not to vote for or against, but to abstain from voting. And a remarkable number of 27 absent from voting. So that's a high number, more than 10% of the number of states. And you can see highlighted in purple are, let's say, Western or European-oriented states. And you can see that quite a number of them were voting for the resolution. I've even got the Russian Federation in there, assuming it's rather Western-oriented. We won't discuss that today. But my point is that this is not just Arab states, it's not just Islamic states who are supporting this initiative, but also European states. Some of those who abstained, like Spain, were very vocal in the proceedings, promoting the idea that the court should adopt this advisory opinion. So it's a very broad number of states, but still it's a minority of states pushing this forward. Here we have the voting, you can see in another form. But again, the majority are not voting green in favour. So the court opened this proceedings to the states of the UN and received a lot of information. Every UN member state was invited to be part of the proceedings, including Israel. It received an enormous amount of United Nations reports, massive amounts, I think over 20,000 pages of UN-produced reports designed to support the idea that Israel has discriminatory legislation, that it is violating Palestinian human rights, their right to self-determination. I think Jonathan Turner will speak a little bit later about the value of evidence before the court. 52 states took advantage of the opportunity to make presentations or written presentations to the court. And 3 international organisations were admitted, and this is also significant. The Arab League, the Organisation of Islamic Cooperation, and the African Union. And every one of those groups of nation states were very hostile to Israel, strongly supporting the strong Palestinian claims to statehood, to require Israel to withdraw from the territories, and undermining the legitimacy of the State of Israel. I'll come back to that in a moment. Israel has not participated in the proceedings. It did submit a short document at the beginning of the proceedings, but it didn't engage with the court beyond that. And other organisations were also excluded. The court takes the view that only these interstate kind of organisations are entitled. So many other organisations, including Jewish organisations, Christian organisation groups of interested parties, do not have the opportunity to be part of these proceedings. You cannot submit amicus curiae briefs to the court unless it invites them, and they haven't invited them. So it's really a kind of a closed setting. So this is the state of Palestine. This is Professor Philip Sands, who is their chief legal counsel. They had a whole raft of legal counsel when they appeared before the court in February. What are the Palestinians claiming? The state of Palestine, by the way, as it is called in the court. This goes back to the resolution of 2012 of the General Assembly giving Palestine non-member observer state status. On that basis, Palestine considers itself to be a state, and the court is willing to recognise it as a state. And it claims Palestinian right to self-determination on the Palestinian territory. They say that this right is an absolute right. It is a right that overrides other legal rights and obligations. It's so fundamental. It's like the right or the obligation not to commit slavery or not to commit genocide. They say that this fundamental human right of self-determination allows the Palestinians to determine their own political and legal future. They say that the occupation of Palestinian territory is illegal. So everything that Israel has occupied, controlled since the June 1967 war, they say has now become illegal because of Israel's settlements and annexation practices. There's a very novel idea that occupation suddenly becomes illegal. We don't have time to go into the details, but that's a novel proposition under international law. And finally, but also importantly, they go on and on about how discriminatory Israel is with respect to the non-Jewish population, even in Israel. The Palestinian demand is for a total, immediate, unconditional end to the occupation. Right? This is a broad claim that Israeli, not only military but also civilians, must be removed from the occupied territory. It requires the court to recognise the Palestinians' right to claim statehood. The right to self-determination, they say, is the right to choose whatever political form they think they want, and that includes statehood. And they call upon third states to pressure Israel to comply with these demands. This is the Palestinian claims. The Palestinians, by the way, were given in a proceedings of 7 days. The Palestinians were given half a day. Every other state participating was given half an hour, but they were given half a day at the beginning of the proceedings to put their case. So there's no doubt this whole initiative is a Palestinian-driven initiative that other states are supporting. It's not like the world community is getting around and putting its case. No, they are coalescing around the Palestinian demands. And we'll come back to why that is problematic. The Organization of Islamic Cooperation, you can see here, 57 member states. Their case was really built around Al-Quds, Jerusalem, and the claim to Jerusalem as a Muslim Islamic place, not only the Temple Mount, but the whole of Al-Quds, and not just East Jerusalem, by the way, but the whole of the city. So the Palestinian/Arab Islamic/African position is a Palestinian right to self-determination. All of Mandate Palestine belongs to the Palestinians. They go right back to the Balfour Declaration and the Mandate for Palestine, and they say this was a fundamental breach of the Palestinian Arab rights to sovereignty over this territory, all of Mandate territory. So the idea of a Jewish national home is somehow illegitimate, even though they're only claiming sovereignty at this point over the occupied territories. If you read into their claims, they go right to the root of Israel's existence based on the mandate. Final point, very important to note, is that they really seek to avoid the Oslo agreements, the agreements between Israel and the PLO. We know that the Oslo process has failed, but nevertheless the agreements are still in force, and they lay out a roadmap towards the full achievement of Palestinian self-determination. And they give Israel rights in areas A, B, and C, particularly C and B. So they determine legally, as between the parties, the rights in relation to the territories. This is all avoided in their claims before the court. They say the right to self-determination overrides the Oslo Accords. This was similar to the case they put before the criminal court. Israel's position, it's good to know, I think, even though Israel is not putting this strongly before the court, but I think it plays into the dynamics of the case. Israel, since 1967, has said basically that it complies with the humanitarian provisions of the law of occupation, but does not regard the West Bank as occupied de jure, as a matter of law, and particularly the Fourth Geneva Convention does not apply to them. In Israel's case, they say primarily because it did not take the territory back from a sovereign state, the law of occupation simply doesn't apply. But because Israel is not claiming sovereignty over Judea and Samaria, it's not asserting sovereignty since 1967, it says sovereignty is in abeyance. It will treat the Palestinians as protected persons under the law of occupation. So it's a rather confusing legal position, I think, but it's one Israel has put consistently. Israel has, I believe and understand, accepted the Palestinians have a right to self-determination, to autonomy. That's reflected in the Oslo agreements. But that the Palestinian entity, whether it's the PLO or the PA or the so-called State of Palestine, does not meet the established criteria of statehood under international law. Further, Israel insists that the Oslo Accords are, at least for the time being, binding and applicable. I think this vacuum in sovereignty has perhaps opened the door for the Palestinians to claim full sovereignty over these territories. Now, there were a small number of states in the court who've been supporting Israel, and when I say supporting Israel, I mean supporting the idea that it's not appropriate for the court to be involved in resolving this dispute through an advisory opinion. They were principally the USA, Hungary, Czech, the UK, France, Zambia, Togo, Fiji. I might have missed one or two. But they were strongly advocating to the court that it's not appropriate for the court to be getting involved in a political dispute. Whether the court will hear that is another question. Republic of Fiji, I just want to highlight, you've got the papers of the Republic of Fiji in your documents. We had the privilege of helping Fiji to make its case before the court. And it was reiterating points made by also a number of other states. The Oslo Accords are still applicable. There is a peace process. There are Oslo agreements. There is an internationally sanctioned peace process. The Security Council, yes, it might envisage the creation of a Palestinian state, but it's through negotiations. This is clear. The roadmap is still on the books. The Security Council's position has been very clear. No Palestinian statehood until negotiations have been completed. At least formally, that's their position, although they're under pressure, of course, from Palestine to recognise Palestine as a UN member state. And thirdly, we emphasise the one-sided nature of the question. We saw the questions, they really presuppose the court that there is already an answer to these questions. Israel is infringing the Palestinian right to self-determination. The occupation is illegal. And Israel is obliged to withdraw from territories. These are all implicit in the question, so the court's being asked to really rubber stamp a set of questions the General Assembly has already given an answer to. And this is clearly unfair and biased. The court can't be entering into a very one-sided kind of inquiry. Okay, moving forward. Okay, 5 more minutes. Okay, so I want to just take you back very briefly to the beginning. This is what is being undermined in these proceedings. The San Remo Resolution of 1920, built on the Balfour Declaration, the Allied powers after the First World War agreeing to the creation of mandates throughout the Middle East and other territories. And the mandate for Palestine included in it. It was a foundational document under the League of Nations, Article 22. And this article is really central to this case before the court at the moment. The Palestinians say, we are the communities of Palestine, not the Jewish people. And so the Allied powers should have been giving the Arab community of Palestine self-determination and not the Jewish people. This, at the end of the day, is really what the court's being asked to determine on. This goes to the very heart of the existence of the Jewish state of Israel, which legally is founded and grew out of what happened after the First World War. The mandate for Palestine here recognised the historical connection of the Jewish people with Palestine and the grounds for reconstituting their national home in that country. This is a treaty document. It is binding on all states who signed up to that treaty, and it laid the foundation for the state of Israel. The mandate for Palestine was unique. It recognised the Jewish national home, the right to close settlement of the land, the right to Jewish immigration, and importantly, the protection of all civil and religious rights of all people of Palestine. This was the mandate territory.
1920.
This is 1920, and the mandate came into effect in 1922. This was Palestine originally before Transjordan was split off in 1921. That was the original idea of Palestine, which was to include current-day Jordan. Now, the Palestinians in the court are really undermining that based on this idea of self-determination as a fundamental human right. They say the law has basically changed. Since 1945, we have a new legal system. It's based on the fundamental recognition of human rights, including the right to self-determination, and this trumps everything else, including pre-existing treaties like the mandates. This is really fundamental, and unfortunately this was not the subject of a lot of debate in the courts, because most of the states supporting Israel were pushing back against the court's jurisdiction, its discretion to issue an opinion. They weren't getting into the substance a lot. And so it's going to be a question whether the court will be persuaded by what the Palestinians have said, supported by all the UN documents. Okay, we don't have time to go through this. It's based on a lot of the teaching of Hirsch Lauterpacht, Jewish professor of law, became a judge of the International Court of Justice. And here we see the two documents contrasted, the Declaration of Independence of the State of Israel in 1948 and also 1948, the Universal Declaration of Human Rights. And these are in some kind of tension today. The foundations of the rights of the State of Israel and this new principles of human rights law. And it's interesting, both of these originated from 1948. Okay, I'm going to bring to a conclusion. This is the Declaration of the State of Israel. The status, the territory and borders of Israel were not established when Israel was created. Israel was established in Eretz Israel. And the principle of uti possidetis juris, legal principle, would say that the borders of the State of Israel are the borders of the mandate for Palestine. It's not in the Declaration of Independence, but that is the principle which should apply and does apply in all other cases of mandates, colonies, and similar territories. Okay. I'm going to slip through this, the Oslo courts. My final slide, why is the UN General Assembly request problematic? Here are 7 things that we would say. We've produced a document elaborating on this in more detail. I hope to have that available to you by the end of the day. If not, we'll send it to you by email, just laying out some of these arguments in non-legal terms, which we hope will be helpful for you. First of all, the Palestinians are rewriting legal history of the Jewish people, the land, and of the State of Israel. This is a complete revision of the legal status of the territories prior to 1948. Secondly, a Palestinian state was bound to be a failed state at the moment. Who is going to govern Palestine? Big question. Professor Bock will talk a little bit about that. Thirdly, the Palestinians have consistently rejected two-state solutions. This was mentioned before the court. The court should be aware of this. The only reason the Palestinians are seeking the court is because they're rejecting negotiations, and there have been many of those rejections. Fourth, the international courts are now becoming involved in politics, not law. This is also true of the genocide cases. Yet they're allowing themselves to be used to reach legal decisions which are really political decisions. Fifthly, these proceedings are unfair and imbalanced. Sixth, the Palestinians are bypassing the internationally sanctioned solution, that is negotiations. And seventh, the Palestinian, Arab, Islamic, and even UN claims distort international law. So thank you so much. I hope that's been helpful, and the other speakers will elaborate more. Thank you.